Okay, let's dive in. Picture this. You're in a high-stakes legal fight. But forget the smoking gun. Forget the dramatic courtroom confession.
Right.
The real weapon here. It's something almost ridiculously mundane. It's a single misplaced decimal point.
Seems unbelievable, doesn't it? Such a tiny thing.
Exactly. But this tiny error, buried deep in a government document, could potentially save one man, and he's a seasoned lawyer, mind you, over $230,000 in taxes.
Wow.
We're setting the scene in 1980s Canberra, Australia. It's an era, of pretty aggressive tax collection, lots of financial pressure, and the legal profession itself is starting to face more scrutiny over its own ethics.
Yeah, it's a backdrop where the rules are being tested. And this story starts with, well, dry numbers, bureaucratic processes, but it spirals fast into real human drama, doesn't it, with massive professional stakes.
It really does, because at the heart of it isn't just a tax squabble. It's about a lawyer using his deep, intimate knowledge of the legal system for his own personal advantage when he spots this massive blunder by the other side.
And that immediately throws you into that gray area, doesn't it?
Yeah.
How far can you push the boundaries for yourself? I mean, is it different than pushing hard for a client?
That's the core question. So this deep dive, it focuses on Terry Chamberlain. He's described as a senior Canberra lawyer facing this really substantial personal tax debt. And when he spots this glaring error in a document filed by the Deputy Commissioner of Taxation, basically the top tax guy, he doesn't just see a typo.
No, he sees an opportunity, a huge one.
But crucially, exploiting this error wasn't some quiet little deal done behind closed doors. Oh no, far from it. This one mistake kicks off this multi-year legal war. It bounces between multiple courts, and it all culminates in this direct challenge to his professional conduct. It nearly cost him his entire career.
What's really gripping, I think, is watching how this seemingly straightforward civil dispute over money just morphs.
Yeah.
It becomes this fundamental test of the lawyer's ethical red lines.
Yeah.
It forces the courts, and, well, forces us listening, to wrestle with that critical question. Just how aggressive can you be using the rules, using your legal know-how, especially when you know your opponent has made a massive, costly mistake?
Exactly. So our mission today, digging into the sources we have, the court judgments themselves, newspaper articles from the time, our own notes, is to painstakingly piece together the intricate details of this whole legal saga.
We need to trace all those procedural twists, the back-and-forth strategies, the clash of legal minds at different court levels.
And ultimately understand why this story, nearly 40 years on, is still such a vivid, dramatic, and frankly vital cautionary tale for anyone thinking about or already in the legal profession.
It's like a real-life legal thriller. The stakes weren't just money, they were reputation, integrity, the very meaning of ethical lawyering.
Totally. It's a powerful example of how tiny details can have these huge cascading consequences, impacting not just the people involved, but the principles holding up the whole justice system.
Okay, let's pull back the curtain then. Act 1, the setup and the trap.
Right. Every good story needs its main character. And here, it's Terry Chamberlain. The sources paint him as, well, a pretty senior figure in the Canberra legal scene, a partner at Gallon's Crowley Chamberlain, known for being sharp, for his legal acumen.
Yeah, not some rookie. He's experienced. He knows the ropes.
Definitely. But he has this problem, a big personal income tax bill. We're talking assessments covering nearly a decade, 1975 to 1983, and the total, a hefty $255,579.20.
Ouch. That's serious money, especially back then.
Absolutely. And he disputed it, lodged objections, but they got disallowed. So the whole thing was heading towards this administrative hearing body, the Income Tax Board of Review. The sources also mentioned he'd actually tried to settle earlier, offered the tax office $25,000, but they'd knocked that back.
So he's already locked in this probably quite frustrating battle with the tax authorities. It's grinding through the system. And then the Deputy Commissioner of Taxation decides to change tack, maybe looking for a faster way or a stronger enforcement tool.
Exactly, and that's the key move. July 1984, the Deputy Commissioner files what's called a specially endorsed writ in the ACT Supreme Court. Think of it as a formal lawsuit demanding payment of that specific bet. It's a direct shot to try and recover the money through the courts.
And right here, this is the moment, the pivotal error, the spark that lights the fuse for this whole complex legal drama. In preparing the endorsement on this writ that's a bit detailing the claim, the amount the Deputy Commissioner's office makes a monumental blunder.
How monumental?
Well, the list of debits and credits, the individual tax assessments for each year, they were listed correctly. If you actually sat down and added and subtracted those figures, you'd get the right total. $255,579.20.
But that's not the figure that ended up as the final claim amount on the writ itself.
Nope. A misplaced decimal point. Simple as that. The writ claimed a total of $25,557.92.
Wait, 25,000 instead of 255,000?
Precisely. Exactly 1/10 of the real debt. The difference, a cool $230,021.28. Just gone, on paper at least.
Wow. And the sources mention something interesting here, that the writ was issued by the deputy commissioner in person, not through their usual government solicitors.
Yeah, that's potentially significant. Maybe a procedural shortcut or just direct action. But it might explain how the usual checks and balances, the kind of solicitor's office would normally do on calculations, maybe got missed.
Right.
Someone didn't double-check the maths before it went out the door.
An accidental jackpot, like you said. Over $230,000 effectively vanished from the claim because of one dot in the wrong place, and Terry Chamberlain being this experienced lawyer.
He's probably one of the people best placed in the whole country to spot that kind of error immediately and grasp its potential significance.
And he does. But interestingly, he first hears about it not from the court papers, but from the newspaper, August 1st, 1984. He reads an article in the Canberra Times about the lawsuit. It names him, and crucially, it reports the incorrect lower amount being claimed, $25,557.92.
So he knows something's up even before he gets the official papers.
Right. Then, that same evening, he's formally served with the writ. He looks at the endorsement, checks the years it covers, and bam! Instantly sees the massive arithmetic mistake, the decimal point.
You can almost picture that moment, can't you? The sources mention his first reaction, according to his later testimony, was actually anger, especially about being named in the press. He felt the tax office was trying to pressure him publicly.
Yeah, that personal element seems to have colored his thinking right from the start, and his immediate thought, quoted in the sources, was something like, if that's all they want, they can have it.
So initially, maybe just pay the small amount, make the public problem go away.
That seems to have been the first impulse. Pay the stated amount, end the lawsuit, stop the embarrassment. But, as the sources describe, he thinks about it overnight. That impulse shifts.
And this is where the lawyer brain kicks in, isn't it? He moves from just reacting to forming a strategy, a very deliberate one. His goal, as he later admitted quite openly under cross-examination, wasn't just to pay the lower amount and be done with that specific lawsuit.
Because that wouldn't necessarily stop the tax office coming after the rest.
Exactly. Paying the $25K might settle the writ, but the underlying $230K tax debt could still be pursued through other means, maybe new assessments or another action. His objective was much bigger, much more ambitious, and, well, ethically fraught. He wanted to use this mistake to potentially shield himself from paying the remaining balance permanently.
Let's go back to that quote from his testimony because it's so revealing about his mindset. He said, and I'm quoting the sources directly, "My object was to lock him, the deputy commissioner, in as tight as I reasonably could to secure the best possible position for ongoing negotiations. To do that, I got him to consent to judgment."
Wow. He's explicit. Locked him in. That's not passive acceptance of a mistake.
Not at all. He laid out his strategic goal, prevent the deputy commissioner from ever recovering the other $230,000 by holding the formal court judgment he planned to get for the lower amount. He even calculated his odds, thought he had maybe a 20% chance of making that judgment stick if the ATO challenged it later.
So he's not just hoping for the best. He's actively planning to weaponize this error. He sees a path using legal principles like res judicata, the idea that a matter decided by court can't be relitigated, or maybe estoppel, preventing someone from going back on their word or position. He saw these as potential legal shields to block the tax office forever. It was a calculated gamble for huge personal gain.
Okay, so the plan is formed, and it unfolds incredibly quickly. Friday, August 3rd, 1984, just 2 days after seeing the newspaper article, Chamberlain gets busy preparing the legal paperwork needed to formally enter the lawsuit and lock in that mistaken lower amount through the court system.
What documents are we talking about?
He prepares an appearance, that's the formal notice saying he's defending the case. He drafts terms of settlement, and crucially, he prepares a draft consent judgment, the formal court order, all for the wrong amount. $25,557.92 plus $115 for costs. And importantly, these documents are prepared under the name of his law firm, Gallons, Crowley, Chamberlain.
Right, using the firm's name and resources. And this is where it gets even trickier ethically. Because he doesn't personally handle the next step, the interaction with the tax office.
No, he involves someone else from his firm, a solicitor employed there, Mrs. Margaret Reed.
He gives Ms. Reed the file, the writ, the documents he's drafted, and he includes a handwritten note. The wording of that note, quoted in the sources, is really telling. It says something like, "Happy to pay the bill, to get my name out of the papers, and a certain result for the whole thing. In principle, I still say nothing is owing, hence the denial of liability and nominal protest built into the terms. Can you confirm and get it cleaned up ASAP?"
Get it cleaned up sounds routine, but what's missing?
What's crucially missing is context. The sources are clear. Mrs. Reed was not told about the decimal point mistake. She had no idea about the massive discrepancy between the amount on the writ and the actual tax debt Chamberlain knew was outstanding.
So he's directing a colleague, his employee, to carry out this plan without telling her the most important fact.
Exactly. He frames it for her as a simple, maybe slightly begrudging settlement. Just pay the amount on the bill, get his name out of the papers, put in a standard no admission of liability clause. He effectively uses her, unknowingly, as the instrument to execute a strategy based entirely on exploiting a major error he hasn't disclosed to her.
Okay, so Miss Reed, acting on these instructions, gets on the phone. She calls the deputy commissioner's office, speaks to a Mrs. Joanne Healy, a clerk in the schemes unit. Mrs. Reed identifies herself, says she's acting for Chamberlain, and says he wants to pay the amount claimed on the writ, plus costs, but wants it finalized with a formal consent judgment from the court.
Imagine being on the other end of that call in the tax office. Suddenly, this guy, who owes a huge amount, is offering to pay the amount on the writ quickly and wants a court order. It caused confusion.
Understandably. Mrs. Healy talks to her supervisor, a Mr. Ingram. Neither seems sure what to do. It's unusual. So Mr. Ingram calls Mr. Philip Saxby over at the Australian government solicitor's office, the government's lawyers.
And what's the key information passed on? Ingram tells Saxby about the offer, and crucially, confirms that the amount Chamberlain is offering to pay matches the amount stated on the writ they issued.
Right. And Saxby's advice, according to the sources, is basically, well, consent judgments aren't weird, and if he's paying the full amount that's actually on the writ, then no harm in it.
Seems logical if you don't know the amount on the writ is wrong.
Precisely. But Healy and Ingram are still a bit hesitant. They escalate it further to Mr. Jeff Besgrove. The sources identify him as the Assistant Director of Enforcement at the Australian Taxation Office, ATO, in Canberra. And they add, quite dramatically, that Mr. Besgrove would unwittingly walked into Chamberlain's carefully laid trap.
Oh, dear. So Besgrove is told about Saxby's advice, probably keen to get a difficult debt case finalized.
And he agrees. Tells them he'll sign whatever needed to be signed.
The trap is about to spring.
It happens quickly. Miss Reed goes over to the ATO office. This is either later that Friday, August 3rd, or possibly Monday morning, August 6th. She hands over Chamberlain's check for the $25,557.92, plus the $115 cost to Mrs. Healy. And Mr. Besgrove signs the document she presents,
Believing it's just the consent judgment form.
He likely thought it was just finalizing the payment of the amount claimed. But the document he actually signed was the terms of settlement drafted by Chamberlain, and those terms read, by consent and without admission of liability, 1. Judgment for the plaintiff in the sum of $25,557.92, together with costs to be assessed and agreed at $115, 2. The settlement money is to be paid by the defendant to the plaintiff forthwith.
And it includes that without admission of liability clause Chamberlain wanted.
Yes. So Miss Reed gets a receipt for the check, leaves with the document now signed by the Assistant Director of Enforcement, acting on behalf of the Deputy Commissioner.
Chamberlain now has the ATO's formal consent, albeit given under a massive mistake, to judgment for the tiny amount. What next?
He needs to make it official with the court. On Monday, August 6, 1984, the three key documents he appearance, the now signed terms of settlement, and the draft consent judgment Chamberlain prepared are all lodged together in the ACT Supreme Court Registry.
There's a little detail about the date on the appearance being changed.
Yeah, the sources mention Chamberlain altered the date on the appearance from the 3rd Friday to the 6th Monday. One judge later, Justice Whitlam, found this suspicious. He suspected Chamberlain might have personally lodged the documents on Monday, knowing the terms had been signed under mistake the previous Friday, and effectively directly arranged the entry of a corrupt judgment.
Strong words. Corrupt judgment.
Very.
Yeah.
Regardless of who physically lodged them, the timing shows Chamberlain was actively driving this. The Supreme Court Registry, seeing the signed consent terms and the matching draft judgment, does its job. On August 6, 1984, they formally entered judgment for the Deputy Commissioner against Chamberlain for $25,557.92. The mistaken lower amount is now officially stamped by the court.
He's done it. He's locked him in, as he put it. The trap has worked. But he knew it was vulnerable, right? He anticipated a challenge once the mistake was found.
Absolutely. So he immediately moves to strengthen his position to make it harder for the ATO to undo this. His very next move, also on August 6th, is critical. He drafts another letter. This one goes to the deputy commissioner. It's on his law firm's letterhead, again signed by Mrs. Reed. And this letter formally withdraws his original objections to all those tax assessments, the ones heading to the Board of Review.
Why do that? Why give up his right to challenge the original assessments?
Strategy. Pure strategy. The letter itself, as some judges later noted, was a bit misleading. It talked about the settlement negotiated on the 3rd August 1984, but there wasn't really any negotiation.
Right, it was just an offer to pay the mistaken amount.
Exactly. But Chamberlain's purpose in withdrawing the objections, which he admitted later under oath, was to build a defense. He wanted to create the basis for an estoppel argument.
Explain that. How does withdrawing objections help him?
He planned to argue later, if the ATO tried to undo the judgment, that he had acted to his detriment because of that judgment. He'd given up his valuable right to fight the original tax assessments at the Board of Review, relying on the fact that the matter was settled by the consent judgment for the lower amount.
So he's trying to create a situation where he can say, you can't undo this judgment now because I relied on it and changed my position by dropping my objections. It would be unfair to let you go back on it.
Precisely. He thought this would make it much harder for a court to set aside the judgment. It was another calculated layer to protect his gain. He figured it reduced the ATO's chances of overturning things.
So within just a few days, spot the error, devise the trap, use his firm and an unwitting colleague to spring it, get the faulty court judgment entered, and then immediately take steps to build a legal wall around it using estoppel. Tactically, it's something.
It's certainly adept from a purely procedural standpoint. But the ethical alarms are ringing loud and clear, aren't they? And that's what triggers Act 2, the legal war. Because the tax office wasn't going to let $230,000 just disappear quietly.
No way. They trigged pretty quickly. August 6th or 7th, right after the judgment went through, Mrs. Healy and Mr. Ingram back at the ATO are looking at the file again. The amount just looks odd to them now, and then they find it the misplaced decimal. The sources say they couldn't really explain why it wasn't caught earlier. A major system failure, it seems.
So they notify their lawyer, Mr. Saxby, who then calls Miss Reed on August 7th to say basically, we think there's been a big mistake here.
The deputy commissioner's response is swift. They realize that first judgment might block them from getting the rest. So on August 10th, 1984, just 4 days after that first judgment, they launch a second lawsuit against Chamberlain in the ACT Supreme Court.
What are they claiming this time?
This time they're claiming the difference. $230,021.28. They're determined to get the rest of the money.
And Chamberlain defends the second action. On what grounds?
He defends it, primarily relying on that first consent judgment he engineered. His argument is basically, you already sued me for the debt, we settled it with a court judgment for $25,000, that's the end of the matter. The first judge to hear this second case is Justice Kelly.
And what does Justice Kelly decide?
Justice Kelly hears the arguments, and on June 18, 1986, fines for the deputy commissioner. He orders Chamberlain to pay the balance. But here's a really crucial point the sources highlight. In that hearing before Justice Kelly, the lawyers for the tax office specifically chose not to argue that the first judgment should be set aside because it was obtained by mistake.
Why not? That seems like the obvious argument now.
It's a bit of a mystery from the sources, maybe a tactical decision they later regretted. They just argued for the balance, effectively accepting the first judgment stood for the lower amount, but claiming the rest was still owed.
Okay, so Chamberlain loses round 1 of the second case. He has to pay the balance. But knowing him,
he appeals. Takes Justice Kelly's decision to the full federal court. But they dismiss his appeal too on February 17, 1987.
So, lost in the Supreme Court, lost in the full federal court on the second action. Surely that's it.
You'd think. But no. Chamberlain seeks and gets special leave to appeal to the highest court in the land, the High Court of Australia.
And what happens there?
This is where he scores a massive procedural victory in the civil tax fight. On May 12, 1988, the High Court allows his appeal. They overturn the lower court's decisions.
On what basis?
On the basis of res judicata, specifically cause of action estoppel. The High Court says the original tax debt, the whole $255,000, was the cause of action. When the deputy commissioner took that first judgment for $25,000, the entire cause of action legally merged into that judgment. As long as that first judgment was valid and hadn't been set aside, it extinguished the original claim. You can't sue again for the rest of the same debt.
So the High Court is saying the tax office basically used up their one shot when they took the first incorrect judgment.
Essentially, yes, unless they took steps to undo that first judgment. The joint judgment from Justices Dean, Toohey, and Gaudron really spells it out. They say, and I'm quoting the source, so long as the respondent, the deputy commissioner, chooses to take no step to set aside the judgment and to raise no issue in the second action as to the circumstances in which that judgment was obtained, he must accept the consequences of res judicata. Justice Brennan agreed.
Wow, so the High Court is basically telling the tax office, you messed up procedurally in the second lawsuit by not attacking the first judgment directly based on the mistake. Because you didn't do that then, you're stuck with the consequences now.
Precisely. It's a huge win for Chamberlain on the civil front.
Yeah.
It looks like he successfully used the flawed judgment as a legal shield to avoid paying the bulk of the tax. But the deputy commissioner isn't giving up on the money yet.
What can they even do now?
Well, the High Court gave them a pretty clear roadmap. If you want the money, you have to go back and directly attack the validity of that first judgment. Specifically, the agreement that led to it, those terms of settlement signed by Mr. Besgrove.
So they launch another case?
Yes, a third legal proceeding. This one is specifically aimed at impeaching or setting aside the agreement, the terms of settlement, on the grounds of mistake. They're finally going after the foundation of the trap itself.
Who hears this third case?
It initially goes to the Supreme Court, but gets transferred to the federal court and comes before Justice Murray Wilcox. He's a federal court judge who, interestingly, had been involved in some earlier related tax litigation involving Chamberlain.
And what does Justice Wilcox make of it all?
Justice Wilcox takes a very dim view of Chamberlain's conduct. He digs into how that consent judgment came about and finds it was obtained by unconscionable conduct on Chamberlain's part. Conduct so unfair, so against good conscience, that the resulting judgment shouldn't be allowed to stand. He orders the first judgment to be set aside.
Unconscionable conduct? That's strong. Did he elaborate?
He did. He used incredibly forceful language. He said the way Chamberlain dealt with the ATO through Mrs. Reed involved a combination of silence and half-truths amounting to a misrepresentation. And then came that really famous damning line. Justice Wilcox described Chamberlain's actions as the moral equivalent of larceny by a trick.
Larceny by a trick, that's basically saying it was theft by deception.
It's incredibly strong judicial condemnation. Not just sharp practice, but something fundamentally wrong, bordering on criminal in its moral character, even if not prosecuted as such.
So, Justice Wilcox sides completely with the tax office. The trap is undone, the judgment set aside. Finally, the ATO can get the money back.
Not so fast. This is the Chamberlain case, remember? He appeals again. Takes Justice Wilcox's decision up to a full court of the federal court.
You're kidding. Another appeal.
Another appeal. And believe it or not, in another major twist, the full court allows Chamberlain's appeal on March 8, 1991. Justice Wilcox's decision is overturned.
How? Why? Did they disagree with Wilcox J's view of the conduct?
Not entirely. This is where it gets really complex legally. The full court actually accepted Justice Wilcox's harsh assessment of Chamberlain's behavior. They used terms like shabby trick and misrepresentation. They explicitly stated the processes of the Supreme Court were improperly used. They agreed his conduct was bad.
So why overturn the decision?
They applied another legal principle of Sapple. This one comes from a different High Court case called Port of Melbourne Authority v. Anshin. The Anshin estoppel principle basically says if you could and should have raised a particular claim or defense in an earlier court case between the same parties, but you didn't, you might be legally prevented estopped from raising it in a later case.
Okay, so how did that apply here?
The full court said the deputy commissioner's argument to set aside the first judgment because of mistake and unconscionable conduct should have been raised back in the second lawsuit, the one for the balance, heard by Justice Kelly way back in 1986.
The procedural mistake the High Court pointed out earlier comes back to bite them again.
Exactly. Because the ATO failed to challenge the first judgment properly then, the full court found they were now legally blocked by Anshin estoppel from raising that challenge years later in this third proceeding, even though they agreed Chamberlain's conduct was a shabby trick.
So the court basically says, yes, what Chamberlain did was wrong, improper use of the court, but tax office, you missed your chance to fix it earlier, so you're stuck with it now.
That's pretty much the effect. Procedure trumped the merits of the misconduct in a way. After this decision, the sources say the deputy commissioner took no further civil action to recover the outstanding tax through this line of cases.
Unbelievable. Let's just quickly recap this procedural maze because my head is spinning.
Okay, quick summary. 1. ATO files writ, makes huge decimal point error. 2. Chamberlain spots it, sets trap, gets consent judgment for tiny amount using unwitting colleague. 3. ATO realizes mistake, files second case for the difference but doesn't attack the first judgment in this case. 4. Chamberlain defends second case, wins in high court using res judicata, first judgment blocks further claim. 5. ATO files third case, now attacking the first judgment based on mistake unconscionable conduct. 6. Justice Wilcox agrees, calls it larceny by a trick, sets aside first judgment. 7. Chamberlain appeals again. Full federal court overturns Wilcox J, saying ATO is blocked by ancient estoppel, should have attacked first judgment in the second case.
What a roller coaster. 7 years of litigation. And the end result, purely on the civil side, is Chamberlain successfully fends off the attempts to recover the $230,000, basically because of the ATO's procedural missteps and how they tried to fix their initial mistake.
He won the Civil War, yes, but the war wasn't over. Because regardless of that civil outcome, his conduct in setting that trap, using the court process to exploit that known error for massive personal gain, that didn't go unnoticed.
By whom?
By the body responsible for overseeing lawyer conduct in Canberra, the ACT Law Society.
So the focus shifts from tax law and procedure to professional ethics.
Exactly. Act 3, the ethical reckoning. The Law Society looked at everything Chamberlain did, setting the trap, using his firm's resources, the way Mrs. Reed was involved, exploiting the mistake through court processes for personal profit, and thought, this raises serious questions about his fitness to be a lawyer.
So they take action.
They do. On June 19, 1992, the Law Society files a notice of motion directly in the ACT Supreme Court. They ask the court for orders requiring Chamberlain to show cause why he should not be dealt with by the court for misconduct or for conduct unbefitting a barrister and solicitor. This is serious. It's a direct challenge to his right to practice.
What's the legal basis for this? What standards are they applying?
The main framework is the ACT Legal Practitioners Act 1970, specifically Part V, on discipline. While there was a disciplinary committee, the Act, Section 41, allowed the Law Society to bring serious matters straight to the Supreme Court. The court had broad powers reprimand, fine up to $10 K then, suspension, or even striking off the roll.
And what's the test for misconduct or conduct unbefitting?
It's a standard developed through case law. Basically, conduct that may reasonably be held to violate or to fall short of, to a substantial degree, the standard of professional conduct observed or approved of by members of the profession of good repute and competency. It's about what good, competent lawyers would consider acceptable behavior.
And the Law Society pointed to their own ethical guide.
Yes, the Guide to Professional Conduct and Etiquette, adopted by the ACT Law Society in September 1984, ironically, just a month after Chamberlain sprung his trap. While not strictly binding law at the exact moment he acted, the court could definitely look at it as strong evidence of the profession's expected standards around that time.
Which rules were relevant?
Several. Rule 3.3 on acting in the client's interest, here, his own interest. Rule 16.1 against dishonest conduct or conduct bringing the profession into disrepute. Rule 16.2 against using unfair or dishonest means. Rule 20.1 on courtesy and fairness to colleagues.
But wasn't there one rule that seemed almost perfectly on point about mistakes?
Absolutely. Rule 20.2. This one is crucial to the ethical debate. Let's break it down.
Okay.
Rule 20.2 said, essentially, if you see another practitioner making a mistake that could cost their client unnecessary expense or delay, you should not do or say anything to induce or foster that mistake.
Yeah.
And, unless it would prejudice your own client, you should draw their attention to it.
So it tries to balance helping avoid errors with client duty, but has a hard line against actively encouraging or nurturing a mistake.
Exactly. That prohibition on inducing or fostering a mistake that causes expense or delay was absolute in the rule. And the Law Society argued that even though the deputy commissioner wasn't technically a practitioner when issuing the writ, the ethical standard owed to an unrepresented opponent couldn't possibly be lower than that owed to a fellow lawyer. Chamberlain's actions had to be judged against this standard of not fostering mistakes.
Makes sense. So this all goes before the ACT Supreme Court.
Yes, and significantly before a full bench, 3 judges.
Yeah.
Chief Justice Miles, Justice Gallup, and Justice Higgins. This showed how seriously the court viewed the matter. They reviewed an agreed set of facts, affidavits, and also character references submitted for Chamberlain.
What were the main arguments in court?
Pretty much crystallized the core dilemma. The Law Society's counsel argued Chamberlain's conduct was grave impropriety affecting his professional character. It was professional misconduct, pure and simple. They said he went way beyond just being silent. He actively induced and fostered the mistake, misused the court's processes, gained unfairly, and brought the whole profession into disrepute.
And Chamberlain's defense.
His counsel argued his behavior didn't meet the threshold for discipline. Relying on an opponent's mistake in adversarial litigation, they argued, isn't automatically reprehensible. They tried to downplay his role, suggesting the inducement was attenuated, meaning the ATO officers made their own mistake, took advice, and signed because of their error, not just because of what Chamberlain did. They argued his actions were within the bounds of professionally acceptable tough tactics, part of the game.
How did the Supreme Court judges rule on this? Was it unanimous?
No, it was a split decision, 2-1. The majority, Chief Justice Miles and Justice Gallup, came down hard against Chamberlain. They found his conduct did amount to grave impropriety affecting his professional character and concluded it was professional misconduct.
Did they distinguish between professional and personal?
They said, even if you didn't call it strictly professional misconduct, because he was acting for himself, it was definitely personal misconduct that so directly bore on the appellant's fitness to practice that it justified the court stepping in. They found he actively induced the ATO officials and procured the flawed judgment. His conduct was clearly outside the range of conduct that was professionally acceptable.
Chief Justice Miles had some particularly strong words.
He did. He found Chamberlain was driven by narrowly perceived self-interest. He deliberately used his legal experience and his position as a solicitor to plan and execute this scheme purely to stop the ATO suing for the full amount. Miles C.J. also heavily criticized how Chamberlain used Mrs. Reed, not telling her the real story, giving her a false appearance of authority, the misleading note, having her sign as solicitor for the defendant.
And the impact on the profession's reputation.
Miles C.J. directly linked it, saying, conduct of such a nature tends to bring the legal profession into disrepute in a general sense. He stressed those fundamental duties, honesty and fairness above tactics.
But one judge disagreed.
Yes. Justice Higgins dissented on the misconduct finding. He just couldn't see Chamberlain's actions as inducing or fostering the mistake, or using deception. He saw it as lawfully taking advantage of an error the other side made. Sharp tactics, maybe, but not misconduct needing discipline unless there was something else improper or deceptive, which Higgins J. didn't find. It really highlights how fine that line can seem.
So with the 2-1 majority finding misconduct, what about the penalty?
They considered the options under the Act: reprimand, fine, suspension, striking off. They heard character evidence for Chamberlain. Competent, respected, long career, isolated incident, seemed out of character. But they also noted he still maintained he'd done nothing wrong, which might raise concerns about his future judgment.
Did they consider a fine?
The majority, Miles C.J. and Gallup J., rejected a fine. Miles C.J. pointed out Chamberlain likely stood to gain far more than the $10 K maximum statutory fine. He felt just imposing a fine would be an affront to public decency, essentially arguing that tax avoided just gets paid by everyone else.
So what did they impose?
A suspension. They suspended his right to practice law for 6 months, a very significant penalty. And on top of that, they ordered him to pay the Law Society's legal costs on a solicitor and client basis, basically, indemnity costs. He had to foot the bill for the Law Society, bringing the case against him, signaling strong disapproval.
6-month suspension and hefty costs. That's a major blow. But knowing Chamberlain's track record in this saga.
You guessed it. He appealed. He appealed both the finding of misconduct and the 6-month suspension to the full federal court. This appeal hearing took place in July 1993.
And the federal court took this appeal very seriously.
Extremely seriously. The sources call it an unprecedented 5-judge bench hearing the appeal in the ACT registry. Chief Justice Black, Justice Lockhart, Justice Jenkinson, Justice Whitlam, and Justice Beasley. Having 5 judges is rare and signals the huge importance and maybe difficulty the judiciary saw in the ethical questions raised.
Both sides had top lawyers again.
Absolutely. Queen's counsel on both sides. For Chamberlain, Mr. P.G. Healy QC leading Mr. P. Dodson, instructed by Henry Davis York. For the Law Society, Mr. H.D. Sperling QC leading Mr. G.C. Lindsay and Mr. R.C. Nichols, instructed by Abbott Tout Russell Kennedy. The sources also say both sides agree that if misconduct was upheld, the federal court should just decide the penalty itself, not send it back.
So same arguments again. Was it misconduct? And if so, what's the right penalty?
Pretty much, yes. Rehashing those core issues before the highest court that would hear the matter.
And the federal court's decision, delivered November 2, 1993. What was the outcome?
It was nuanced. A split decision again, but in a different way.
Okay, first, the misconduct finding. Did they agree with the Supreme Court majority?
Yes, they did.
Yeah.
By a 4-1 majority, the full federal court affirmed the finding of professional misconduct. Chief Justice Black, Justice Lockhart, Justice Whitlam, and Justice Beasley all agreed with the ACT Supreme Court majority that Chamberlain's actions crossed the line.
Any particular reasoning stand out?
Justice Lockhart gave detailed reasons, and Chief Justice Black and Justice Beasley specifically agreed with him on the misconduct finding. He used terms like slick tactics, sharp tactics. He was clear. The ATO settled because of their mistake, which Chamberlain knew about. But crucially, Lockhart J. said, but without Mr. Chamberlain's efforts, there would have been no settlement.
So emphasizing Chamberlain's active role again.
Yes. He stated Chamberlain deliberately set in train the events and documents which led to the entry of the consent judgment. He found Chamberlain knew the deputy commissioner had made a large mistake and took unfair advantage of it for his own benefit. He concluded Chamberlain obtained an advantage by more than mere silence. It wasn't passive, it was active exploitation.
And the use of the court process.
Lockhart J. found that using the Supreme Court procedures purely for tactical advantage, knowing the judgment was based on mistake and relying on a contrived estoppel to make it stick, was improper.
Who was the one dissenter on misconduct in the federal court?
That was Justice Jenkinson. Echoing Justice Higgins from the court below, Jenkinson J. just didn't think the conduct met the standard for professional misconduct. He felt the adversarial system allows taking advantage of errors. He couldn't see a meaningful ethical difference between getting a consent judgment based on the mistake and other ways of benefiting, like just paying the wrong amount or letting default judgment happen. He wasn't persuaded that legal practitioners of good repute and competency would, or that a court should, characterize what he did as professional misconduct. He would have thrown out the Law Society's case entirely.
Okay, so misconduct finding confirmed 4-1. What about the penalty? Did the 6-month suspension stand?
This is where the federal court majority parted ways with the Supreme Court. By a narrow 3-2 majority, they decided to reduce the penalty. Chief Justice Black, Justice Lockhart, and Justice Beasley voted to set aside the suspension and replace it with a formal reprimand.
Why the reduction? What was their reasoning?
Again, Justice Lockhart gave the main reasons, with Black CJ and Beasley J agreeing. They felt the misconduct, while definitely warranting a finding, was at the lower end of the scale of seriousness for professional misconduct cases. They put a lot of weight on the mitigating factors, the isolated nature of the incident, a one-off, not a pattern, and the significant evidence of Chamberlain's otherwise good character and high regard in the community over his 25-year career.
So context mattered to them for penalty.
Yes. They felt a 6-month suspension was disproportionate to the gravity of the offense, given those factors. A reprimand, they reasoned, was still a serious formal censure, but wouldn't have the same devastating impact on his practice and reputation as a suspension.
But it was a close 3-2 vote on penalty. Who dissented?
Justice Whitlam dissented strongly on the penalty. He thought the original 6-month suspension was absolutely correct and should have stood.
And he used that strong language again.
He did. He repeated his view that Chamberlain had directly arranged the entry of a corrupt judgment. He stressed he used the word corrupt deliberately because the ATO's consent wasn't real consent. It was based on a mistake Chamberlain knew about and exploited. Whitlam J. clearly believed this abusive court process demanded the tougher penalty.
So let's summarize the final orders from the full federal court. What was the ultimate outcome?
Okay, the final orders were 1. Appeal allowed, but only partly, on penalty. 2. The Supreme Court's 6-month suspension order was set aside. 3. It was replaced with a formal reprimand. 4. Otherwise, the appeal was dismissed, which means the finding of professional misconduct was affirmed, and critically, the Supreme Court's order that Chamberlain pay the Law Society's indemnity costs was also affirmed. He still had to pay their legal bills for the disciplinary case.
So he avoids suspension, keeps practicing, but gets formally reprimanded by the highest court that looked at his ethics and pays a hefty price in legal costs. Not exactly vindication.
Not at all. It was a significant censure, even if not suspension. And regardless of the precise penalty for Chamberlain himself, the case etched itself into Australian legal history. Chamberlain v. Law Society of the ACT became this landmark, a touchstone for the limits of adversarial conduct, as the sources put it.
It answers those tough questions, doesn't it? How hard can you play? When does being zealous cross into being unethical?
It provides some answers, yes, though debated ones. The core principle it hammered home is that a lawyer's job isn't just about winning. There are higher duties to the court, to the integrity of the process, to the public's trust in justice. That quote, often cited from Sir Thomas Lund and echoed by judges like Lockhart J., captures it. A lawyer ought never to fight unfairly, though he is bound to use every proper and fair effort to bring his client's cause to a successful issue.
And deliberately exploiting a huge fundamental mistake by your opponent that's fighting unfairly.
According to the majority in Chamberlain, yes. Especially when it goes to the very heart of the case, like the amount claimed. This wasn't a tiny procedural slip-up. It was a $230,000 error actively exploited. That violates the duty of fairness and integrity.
It also really defined sharp practice, didn't it? Tactics that are sneaky, unethical, even if not strictly illegal.
Absolutely. Chamberlain's conduct, with all those judicial labels, slick, sharp tactics, trap, corrupt judgment, shabby trick, became the textbook example of sharp practice to avoid. The case drew a line. Actively fostering a significant mistake, not just staying quiet about it, is misconduct. The intent to deceive or lock in the opponent was key.
And a crucial lesson for lawyers acting for themselves.
Yes, you don't get to take off your ethics hat just because you're the client. Professional standards apply when you're dealing with the law, period. The Supreme Court even flagged it as potential personal misconduct, directly affecting fitness to practice. Your status as a lawyer comes with constant ethical obligations in legal contexts.
The case also touched on honesty being more than just not telling lies, right? Misleading impressions, omissions.
Exactly. The courts found that creating a misleading impression or staying silent when there's a duty not to foster error can be dishonest. Lockhart J's point about gaining advantage by more than mere silence and Wilcox J's finding of misrepresentation highlight this broader view of professional honesty.
Did the case actually lead to changes in the rules?
It did, directly. It acted as a catalyst for reform in the ACT. Back in '84, the Legal Practitioners Act lacked detailed definitions of misconduct. The split judicial opinions, especially Jenkinson J. questioning if it even fit the definition, showed a gap.
So they fixed it.
Yes. The ACT legislature amended the act in 1993, right after the federal court decision. They put in explicit definitions to make sure deliberate trickery or dishonesty in practice would clearly be misconduct going forward. It also influenced later national rules, like the Solicitor's Conduct Rule 22, about not taking unfair advantage of an opponent's obvious slip.
And finally, reputation. It helped him avoid suspension, but didn't erase the misconduct finding.
Precisely. His good character evidence was vital in reducing the penalty. But it couldn't excuse the breach itself. It shows how valuable reputation is, but also how fragile. It underscores why lawyers need to guard it so carefully.
How was the case received publicly and professionally?
It got press coverage, like that Canberra Times headline. Suspension order overturned for slick local lawyer. You can sense the mix of procedural outcome versus ethical judgment there. Within the legal world, it was huge. A senior lawyer censured for sharp tactics, it was discussed, debated, a very real-world example of ethical boundaries being tested and breached.
And the impact on Chamberlain himself.
He continued to practice after the reprimand replaced the suspension. But practicing with a formal federal court reprimand on your record is significant. It's public, needs disclosure sometimes, carries a stigma, especially in a smaller legal community like Canberra's was then.
And its legacy today, still relevant.
Hugely relevant. It's a staple in legal ethics courses in law schools across Australia. A go-to case study on unacceptable adversarial conduct. It gets cited in disciplinary hearings all the time when tribunals are deciding if a lawyer crossed that line, especially regarding exploiting mistakes or sharp practice.
So the ultimate cautionary tale for aspiring lawyers, barristers, solicitors.
Absolutely. Skills are vital strategy, acumen, spotting opportunities. But they must be paired with integrity, honesty, respect for the justice system. Winning by deception, by exploiting major errors, even if you somehow win the procedural game, carries an enormous professional cost. Disciplinary action, reputational ruin, loss of public trust, these are the risks. The drive for victory, for your client or yourself, can never justify overriding those fundamental duties to the court and to fairness.
It's a constant balancing act, isn't it? But Chamberlain shows there are clear lines you just don't cross.
Lines that protect not just the parties, but the integrity of the entire system. Your conduct reflects on everyone in the profession.
Okay, let's try and quickly summarize this whole incredible story one last time. It starts with a misplaced decimal point. A sharp lawyer sees a chance to dodge a massive tax bill. He sets a trap, uses an unaware colleague, gets a flawed consent judgment. Then, years of intense legal battles, res judicata wins him the second case, and estoppel wins him the third civil case, despite judges calling his actions things like larceny by a trick.
But then the Law Society steps in. Disciplinary proceedings follow. The Supreme Court finds grave impropriety, professional misconduct, orders a 6-month suspension. He appeals again. A 5-judge federal court confirms the misconduct finding 4-1, but reduces the penalty 3-2 to a reprimand, though makes him pay the Law Society's costs.
An epic saga born from one tiny mistake.
It really highlights that tension, doesn't it? The push and pull in the adversarial system between fighting hard for your side and upholding those higher duties to the court and to justice.
Which leaves us, and you listening, with that final thought to chew on. In this competitive system where zealous advocacy is prized, where do you draw the line? If you spotted a similar error, a huge mistake by your opponent, one that could change everything for your client, or even for you personally, what would you do?
The courts in Chamberlain drew their line pretty clearly. They said actively fostering the mistake, deliberately building a trap around it to snatch an unfair advantage that crosses into professional misconduct.
It's a reminder that the pursuit of the best outcome has limits. It has to be tempered by fairness, by honesty, by that fundamental duty to the integrity of the whole legal process. It's not just about what you can legally get away with, it's about what's ethically right. That line defines not just your tactics, but ultimately your character as a lawyer.